On this matter of the disclosure,
Yes.
when the application came before Justice Tom, she made a ruling in June of 2011, and at paragraph 77, I'm again reading from the paragraph 77 of Justice Tom, she states, Parliament not having included discovery, and indeed the interlocutory process in the determination of election petitions, it would be wrong for the court, by way of its inherent jurisdiction, to include it.
Go back to the Constitution on that.
The
authority of the court on this matter.
The authority of the court conferred by the Constitution is clear at section 40. It says, very simply, the High Court shall have jurisdiction to hear and determine any question whether any person has been validly elected as a representative or senator. So even if there were
some issues, the court has a responsibility.
The court has a responsibility clearly assigned by the Constitution. Now, there is the House of Assembly Elections Act, which governs elections in the country, and there's some provisions in there as to what should happen with petitions and so on, election petitions. But Section 68.2 of the House of Assembly Elections Act is interesting. It says rules not inconsistent with the provisions of this act or any law as to the deposit of security and the practice and procedure for the service and hearing of election petitions and matters incidental thereto may be made by the Chief Justice. So you have heard, Afi, over the years as we've had these election petitions, that the civil procedure rules do not apply to election petitions. Lawyers have used that, one side and the other side, to score points in the court.
Absolutely, both sides, all sides.
Right? But you have the Parliament now telling you, to the extent that the Chief Justice feels that he needs rules, he may go ahead and make them.
But the Constitution seems to be saying he shall.
The Constitution says the court has jurisdiction.
Yeah, the court has jurisdiction.
What Justice Tom is saying here, Parliament not having included discovery. So in other words, in the rules that are available under the House of Elections Act, there's no provision for discovery of information, of evidence, so that the passport now, they ask for discovery of the passport, disclosure of the passport to the court. She's saying the Parliament did not include that in its arrangements for the trial of election petitions. But she's also saying something else. And indeed, the interlocutory process. What is the interlocutory process? It is that which comes between the beginning and the ending of a lawsuit or proceeding that either decides a particular point or matter that is not the final issue of the controversy before the court.
In common language, what does that mean?
Well, it means all those little arguments that you have before, all those applications for this and for that, all those, like strikeout, the application to strike out, that is interlocutory. It is interim. The application to set aside the subpoenas, that is interlocutory. Justice Tom is saying she has no authority from the Parliament to deal with that.
But the authority...
And she cannot, because she thinks it would be wrong for the court, by way of its inherent jurisdiction now, to include it. But that creates a problem for me, because I don't understand, if the Constitution is giving you jurisdiction, why, if you need it, will you not invoke the inherent jurisdiction of the court to control your process and to ensure that matters that are important for the determination of the issue before you, in fact, come before the court? Because she goes on in that same judgment, that same ruling of June 2011, to tell us, to remind us about this important power of the court called the inherent jurisdiction. She quotes the learned authors of Halsbury Laws, 4th edition, volume 37. I need to read it, it's important. In sum, it may be said that the inherent jurisdiction of the court is a virile, viable doctrine and has been defined as being a reserve or fund of powers, a residual source of powers, which the court may draw on as necessary whenever it is just or equitable to do so, in particular to ensure the observance of the due process of law, to prevent improper vexation or oppression, to do justice between the parties, and to secure fair trial. Isn't that what the disclosure and the presentation of the passports of these honorable gentlemen in the Parliament would have done to the case? Give you a basis for the truthful, righteous, just determination.
Sounds that way to me. Let's talk about if Dominica could speak, as my dear friend Arundel would say, what would she be saying? What does Dominica say about this development this week? What are the implications for Dominica? What are the implications for Dominicans? I want us to talk about that in not just legal terms, but in social and political and economic terms. Yes.
I think if Dominica could talk, Dominica would say that it is concerned that the ruling suggests that a judge was more concerned with the rights, privileges of the respondents than she was with the rule of law and the Constitution, the constitutional provisions, and the matter before her, indeed, because I think my own opinion is that it was an unsound judgment. I think it's not a judgment that celebrates the triumph of truth, because clearly the way you could have established the truth was by simply allowing presentation of the passports to the court. Not having done that, you came back to say that the gentlemen were properly qualified for nomination and election because you saw no evidence, because no evidence was led. When you ignored the circumstantial evidence and prevented the direct evidence of the passport from coming into court on 2 occasions, the occasion of the application for disclosure and the occasion when the subpoenas were issued against Mr. Skerritt and Mr. St. Jean to bring them in to testify and to bring their passports. So that we know Mr. Skerritt, for example, had a French passport, but he was allowed to withhold the truth of his possession of the French passport from the court, the very court that is required by the Constitution to confirm the validity of his membership in Parliament. I ask you to keep in mind that this is a gentleman who is sworn to uphold the Constitution as a member of the Parliament, who is sworn to uphold the rule of law, who now is talking about the Constitution and now is talking about the rule of law when he has just emerged from a court case in which it was savaged for 2 years.
What will this do, or has this done, and can it do to our perception of rule of law, a society in which the law rules, where there's justice, where there's access to justice? I mean, are these issues, I mean, the ordinary man and woman of Dominica watching what has happened?
Yeah. Well, why should the ordinary man and woman worry about a constitution which appears to be the footstool of certain privileged interests? Mr. Skerritt stood up and said to us, no law, including the Constitution, could prevent him from being nominated as a candidate in VACAS, even though he was aware that he had a disqualifying vice. The judge has now agreed with him, and there's great rejoicing in the street that somebody who has lied about their status in Parliament has succeeded.
So what does that mean?
It means
the way forward
it means we have some serious issues. Remember, we are a country under God. We are a country that prides ourselves on a civility that is based on adherence to the rule of law. But we are glorifying at the same time lies. We're glorifying trickery. We're glorifying deception. And we're glorifying, in this case, in my view, judicial absurdities.
I met a gentleman, an elderly gentleman, on the streets of Rome.
So what are we saying to our young people? This is the question.
This is the question, and that's what the gentleman said to me. He said, you know, Afi, what this is saying to us is that we no longer are a country of laws. We are a country of lawyers.
Right.
Very subtle but crucial difference.
Yep.
And he reminded me that we have over 70 lawyers admitted to the bar in Dominica today. Did you know that?
No, I didn't know that. Didn't notice that many.
1 per 1,000 kind of thing. And he says this must frighten anybody who felt that their last resort, in any case, would have been those courts, hallowed, sacred, objective, unbiased. So All these things are brought into question? Is that what you're suggesting? Yeah?
All these things are brought into question. The integrity of our judicial system is brought into question because, you see, the people have to be able somehow to rely on independent adjudication of matters in the court. In this case, we don't get the sense that the judge was inordinately concerned with the Constitution or the rule of law. It seemed, when you read this judgment, it seems she was more concerned with protecting, upholding, defending, promoting interest of certain litigants in the proceedings.
This part of this case is over. This case.
This part of the case is over.
This part of the case is over. Would it be sensible, fair, useful to say to, let's say, Skerritt right now, Roosevelt Skerritt, okay, the case is over. Do you mind showing us the passport? Just so we can... would that be too coy, too whatever? I mean...
He's not going to do that.
No, but the case is over. You won.
They might appeal.
Oh, they might appeal. Okay,
they might
right.
appeal.
Okay, let's go. Lennox, any connections between this and the society we call Dominica? We have young people looking for work. We have elders looking for safety. We have, businesses struggling to survive. That's the real world in which people live on a daily basis. Bills to pay, salaries that can't go the distance, and then this on top of it. Is it oil and water? Is there a connection? Is there some,
It's all connected. I think we have to find the moral authority to govern. We have to find the moral authority to lead. And if, to the extent that crime is an issue for us, to the extent that lawlessness is an issue for us,
right,
those who sit in our government must have the moral authority to move us out, to lead us out of the lawlessness, to lead us out of the criminality. When the leadership of that group can be making statements like no law, no constitution can stop them from doing this or that, and when those statements get upheld and embraced in the court system, in very, very questionable sort of circumstances of judicial conduct and procedure, you ask yourself, well, where are you going? What message are you sending to the very same young people whom you're telling, don't lie, don't cheat, don't steal, don't look at drugs, don't think of money laundering, don't think of illicit enrichment, don't think of any of these things. But those who seem to be going down that route are those who do well, those who prosper. And the examples, therefore, the right examples we're looking for our children are not coming through from the leadership of the country. All of those who were celebrating yesterday, on Tuesday, the day of the decision, need to ask themselves some questions.
Okay.
And those questions are, what were you celebrating?
Okay.
If it is that you have not understood the case, you don't understand what the constitutional or rule of law implications are, and you're merely celebrating the news that the prime minister you love has won a case in the court without more, that's fine. But if by any chance you understand that this was about Mr. Skerritt refusing to tell the truth about his status as a French citizen, and whether or not he held a passport, which would have disqualified him from sitting on a parliament according to the Constitution, if he tricked and deceived his way to maintain his place in the parliament, and you were celebrating that, then we have a problem.